Right. I think we'll make a start because it is just after 6 and we have got quite a few people already logged in. And this webinar is being recorded, and so it will be available for people to watch at their leisure later on. So good evening, everyone. I'm sorry that I can't see you. I can see the names and I can see the boxes. And so good evening and welcome. Thank you all for giving up your Friday evening to be with us and take part in the BSN Grassroots series of seminars. It's a special program for students. I'm really pleased to have with me this evening with us Grace Brown, who's a barrister at Garden Court Chambers. I'm not going to do a long introduction because part of tonight's proceedings is for Grace to be able to tell you herself a little bit about her journey to law, and ultimately being a specializing in, I think it's one of her specialist areas, is asylum and immigration. So I will hand over to Grace in a moment or two. But before we started, I just thought I would just speak a little bit about immigration and asylum, because it is mainly a student audience, and I'm not sure how much each of you actually know about immigration and asylum law. It is, when I started doing immigration 30 odd years ago, it was not something that ever featured in the newspapers. As an area of law, it was not the political issue that it is today. I don't think very many people had a view about asylum and refugees, and the conversation is certainly not what it is now. And there are a lot of the perception is different to the reality, and there's a lot of misconception as well. So it's becoming an increasingly complex area of law, which for lawyers and for judges, it can at times be a minefield, a political minefield that we have to negotiate. And immigration is not just about refugees. It is, and it's not just about marginalized groups either. You have, I have had millionaire clients who want to sort out citizenship, that they might be from a European country, and they're in and out of the country, and they don't fit necessarily in the rules, and they want advice. There are a lot of business people who, in terms of the visa system as well, there are highly skilled migrants. Again, you don't hear very much about them. And of course, there are a lot of students as well, which some of you will be international students. Your friends will be international students. And so you don't always get that positive spin from the media, from the press, in terms of the importance of immigration and the relevance it is to all of our lives and the economy. So I just thought it was important that we have that sort of context as we start the conversation this evening. So you will have seen that I was an immigration practitioner for 30 odd years. I'm still an immigration practitioner and consider myself a specialist in that area of law. And I've been a fee-paid immigration and asylum judge for the last 20 years. And the distinction with being a fee-paid judge is, in the main, and certainly at the time I was appointed, you could not become a full-time judge unless you were part-time, later called fee-paid, for a certain period of time and gain some experience. Then you would apply to become a full-time judge. But the remaining as a fee-paid judge gives you the opportunity to continue in practice, whereas if you become full-time, you weren't allowed to go back into practice once you made that election. So I chose to continue to be part-time and still part-time, so that I can continue to provide advice and assistance in practicing immigration law. So I'm going to hand over now to Grace so that she introduces herself, talks about why she decided to do law, and then the aim is to have a conversation. We don't have a Q&A function, but there is the chat bar. So if you do have questions, please put them up. We are trying to limit the time to 45 minutes. So if there are a lot of questions and we can't get through them all tonight, we will endeavour to answer them and get back to you anyway. So please do use the chat so as we're going along, any questions that you have. And as I said before, the proceedings, I'm used to being in court, but I'm trying to avoid saying hearing. The webinar is actually being recorded, and that's going to be, the links will be sent out to you sometime after this evening. Grace.
Thank you, Cordella. I'm very happy to be here. Thank you for inviting me, and thank you to everyone for attending on this Friday evening. So just before I start, I have explained to Cordella that my computer hasn't been working well today. I now realise why, actually, because I installed some updates yesterday, so it does keep crashing. But if that should happen, I'm going to rejoin on my phone, and I just apologise in advance if that should happen. So a little bit about me. You know that my name is Grace Brown, and I'm a barrister, and I'm in chambers at Garden Court Chambers. So I was called to the bar nearly 26 years ago, and my route to the bar was somewhat unconventional. I don't know if there is a typical route to the bar, but certainly when I came to the bar in the 1990s, it certainly felt like there was a typical route. There very much was a standard, if you like, of people coming to the bar who had been educated at private school and gone to either Oxford or Cambridge, and possibly also had a family member who was either a judge or a barrister. And certainly my contemporaries at the time when I was training, there were a large section of them were from that background. So I did consider myself to have come from an unconventional background, because my parents had migrated to the UK in the 1950s. So they were part of the Windrush generation, because they came from the Caribbean and from Jamaica. And although they were skilled and had sort of their own trades, in fact, they weren't able to find work in their occupations. They very much did manual work. So that was that background of my parents. That we and I lived in a council house all the time until I went to university, and I went to a state school, so that sort of may be different from the people I came to be training with later on. All sorts of things happened, as things do when you're going through school and education process. But one of the upshots of that was that the school that I was in anyway sort of closed down before I actually did any exams, so I actually ended up leaving school without anything. But I went on to do what was called at the time night school, and I did several courses and ended up with reasonable outcomes from those, and I was able to go to university in my early 20s. So I went to London University, Goldsmiths College. I did a degree in social science and public administration because, well, I still am interested in politics, and I was at the time. But during the course of that course, I became more interested in law, really. And so at the end of that course, I did what was called then a CPE course, which is a conversion course, a one-year conversion course. And then I went straight on to bar school, and from there I went straight on to into pupillage. I should say that obtaining pupillage was an extremely competitive process, as it is now, and it was very difficult due to finances, because at the time, if you were going to do a pupillage, you generally would be unpaid. So you would be doing work unpaid for 1 year, but that is against the background of having been to university, obviously, for 3 years, doing a CPE course for 1 year. So 5 years without an income is quite a lot. I was lucky enough to secure a scholarship and a bursary when I went to bar school, because I found that once I'd got to university and then did the CPE and bar school, all of my grades were way above average, near the top, so that I was able to get funding, really, to support me during that time. That's not to say that I didn't work separately, because I did all sorts of bar work and other types of work. So I came to, that's my background, and I started in a set of chambers in Gray's Inn. That chambers was what's called a common law set. They did a whole range of different types of law. I was very much encouraged to do criminal law at the time, and I did do criminal law for a year or two, but I was very interested in immigration and asylum, or primarily immigration, partly because of the experiences of my parents and their peers and people that had come to the UK around that time, slightly before and after. It didn't really occur to me until much later as an adult, and during my time at university and bar school, that I started to appreciate the injustices that were around people who had migrated for one reason or another to the UK, and how differently they were treated without justification. So I perhaps didn't have that in my vocabulary at the time, but certainly looking back, that was what was driving me into the area of law that I wanted to do. And I wasn't particularly encouraged to do that, partly related to what Cordella has touched on, is that immigration wasn't a thing at the time. It wasn't really, it certainly wasn't anything like it is now. There were three really main immigration acts: the Immigration Act 1971, 1993 Asylum Appeals Act, and then another one that had come in the 1996, which was new at the time. Now we have really, really big immigration acts almost every 2 years, something like that. So when I expressed an interest to do immigration and asylum work back at the beginning of my career, it really wasn't encouraged by people in chambers, the more senior practitioners. They were encouraging me to do crime and perhaps other areas, but I was interested in it. I sought it out. I did a lot of what we call pro bono work, not least because there was no funding at the time, immigration funding, and we might come up, legal aid funding. We might come on to talk about that later on. But yes, so that's how really I came to do asylum and immigration work, and that's a little bit about my background in Cordella.
Well, a little bit different to mine, but I think, well, you see the grey hairs, so I'm a bit older than Grace. So I decided to go down the solicitor route. I'm first generation Windrush, as we're now called, because I came to the UK when I was 4, when Jamaica was still British. And so at the time that I came to England, it was a very different country to what it is now. There were actually a lot of black children of my age, but any of you who have followed the Steve McQueen series of films, you will be aware of the position in the 60s and 70s where black children were being labelled as educationally subnormal, and so the education experience for my generation was challenging. However, again, my parents were from manual backgrounds as well. At that time, there were, I cannot think of any other black solicitors that I was aware of. And the few Black barristers who were coming over at that time, would have been still in the coming to the end of the colonial era. So people were mainly coming from Commonwealth countries to study at the bar and return to Commonwealth countries, West Africa and the Caribbean primarily. So the idea of doing law at all was pretty, what are you talking about? How can you be, why do you think you can be a lawyer? Why do you think it's just not for you? And so there was no, and again, amongst my peers, amongst my family, it's not something that anybody had actually thought about, and so could really encourage and give any direction. So I very much had to work it out for myself. I grew up in the civil rights era, coming to the end of civil rights era. So in terms of apartheid in South Africa, the rights that were going on in the US, the rights that were going on here, the independence movements that were going on in Africa and the Caribbean, all of that was sort of shaping my development and making me convinced that law was what I wanted to do. I thought about the bar, because, as I said, the only thing I'd actually heard of at that stage as a lawyer was the bar. I didn't actually know anything about solicitors, but at some point in time, in fact, my mother was a cleaner, and she was cleaning at one of the places where she was working as an evening cleaner around our school hours, was the city solicitor's office in Birmingham, where I grew up. And I used to meet her there occasionally, and that's where I came across a female solicitor. And that's why I then realized that this was something I could do, and found out how to go about it. So I went to a state school, I went to grammar school, but during all of that, I was still told I couldn't do law. I was determined that's what I was going to do. I'd find a way to do it. I never had a prospectus. No one told me that how to get to university, how to apply. So when I got my A-level results and went to the careers office and said, I want to do law, and she gave me a couple of polytechnics, and I just rang them. And the first one that said yes, I went to, which was North Staffordshire Polytechnic, and I did my law degree there. And one of the reasons I decided I wanted to be a solicitor is that I wanted my own firm. And I'd always wanted, I think I've always been pretty independent of mind. And I felt that if I had my own firm, I can then decide the type of work that I do and who I do it for. I didn't want to work in the city. I didn't want to work in a large corporate practice. By the time I qualified, it was big bang, the city was opening up. There may have been opportunities as a trainee then, but I didn't go that route. I wanted my own firm, and ultimately that's what I did. That after, you have to wait for 3 years after you qualify as a solicitor before you can open your own firm. Within 2 months of completing that 3-year term, I had my own firm. So far as, by that time, I had been working in law for about, for 5 years. So I had acquired I had quite a following by then, because, as I said, this is going back to the early 80s when there are very few Black solicitors around. Perhaps there was a dozen of us in the whole of the UK. Can you go on mute, please? Right, thank you. Yeah, there were a handful of black solicitors. There are a few more barristers, but certainly not solicitors. And it meant then I was really practicing all areas of law initially, because people were coming to me from all over the UK because I was a Black woman, really, and it was a lot of Black people were coming because there just weren't many of us around. And then I stumbled. I wanted to be a criminal defense lawyer. So that is what I started. That's what I did for the first 3 years. I wanted to be a criminal defense lawyer. There are lots of issues with the police, with wrongful arrests of young Black men, We had the riots as well, and so criminal defence law was all I was interested in for quite a long time, and that was the start of my career. And so I stumbled into immigration and asylum. Well, immigration initially. I did immigration, not asylum, for many years. And again, that was because of people coming to me. At that time, we didn't have the thousands of pages of immigration rules that we now have. I think we had a slim volume which hardly had any information, and it was someone who had come to me who'd had a problem with an entry clearance officer when she arrived, that they didn't give her the period of time that she'd asked for. I just rang them, found the number, rang them up, told them off, and got her the status that we wanted. And that was after that, more and more people would then come, and it was start sorting out their immigration issues. So it was a completely different way back then. The Home Office was approachable. You just had to write them really nice letters on behalf of your client, send them a few documents, and more often than not, you would get whatever it was you asked for. Asylum only really took off in the 90s. I think primarily with, there was, in terms of the numbers that we see, and you will find that in immigration and asylum law these days, it really does follow the politics of what is happening geopolitically, that if you are having issues, crisis in countries, then people obviously want to move and want to get away from that. And so it was sort of large migrations and refugees which followed certain wars. So for instance, with problems in Ethiopia, with the famine in Ethiopia and other problems, you started to get large numbers coming then. With the Kosovan war, you got large numbers then, and Turkey with the Kurds. And so I was in Tottenham in North London, which has a large Kurdish community, and one of my employees was Kurdish, and so we started getting a lot of Kurdish people coming to us, and that's how I ended up doing the firm itself. We had 2 people doing asylum, and it's asylum law at that time was interesting because it was new, it was being developed, and also you got an opportunity to do judicial reviews. And in most areas of law, you're not really using your law, you're using it's sort of practice and experience, particularly in immigration at that time. Immigration is the rules, and you're sort of trying to follow the rules or work around the rules. But in asylum, that gave you much more opportunity for challenge, and by going to the High Court and judicial review where you're arguing law. And that's what then appealed to me. And I found that I started specializing in immigration and family law. By then I'd also been doing, I had my own practice. I had a number of solicitors working in the firm, and we practiced different areas of law. And I specialized in immigration initially, and then family, and had other people working in the firm doing different areas of law. And then I think in sort of the issue started to arise about the lack of diversity of the judiciary, which is a conversation that is still going on today, but it had started back in the 1990s when I first qualified. We didn't have any QCs who were Black at all. And so there are issues about diversity in the legal profession. Primarily, it was the bar that we were looking at that time. The Law Society said there was no discrimination and they weren't interested in dealing with it, when of course we know better. So the conversation moved on to the lack of diversity in the judiciary. And it was a speech by Lord Mackay at the Minority Lawyers Conference that we arranged, where he was trying to encourage people to apply. And I remember he said, don't be shy, apply. And by then I was involved with BSN. We'd been lots of campaigning. I applied on the basis that I wouldn't be appointed, but for me to continue arguing the case, I needed to apply and be rejected to give more force to my argument. And I applied and I was appointed. So, and I've been a fee-paid judge, as I said, in immigration and asylum ever since. So we haven't got any questions yet, so I'm going to go back to you, Grace, then, and just ask them about your sort of day-to-day work, really. So your life as a immigration and asylum practitioner. I think she's frozen. Right. I think, Grace, she had mentioned that she was having problems and would try to get back in on her phone. So let me just type her a message quickly and then hopefully she'll get back. In the meantime, I'll just, the question here from Natalie. I'm not sure, sorry, when you're asking about colleagues, whether you, well, for me, whether you meant judicial colleagues or whether you meant other lawyers. Because so far as lawyers are concerned, I think it's certainly not something that's come up with people that I've spoken to about them having any specific issues themselves, but their friends, they obviously often come to me with problems that friends might have. And in terms of the second part of your question about BME representation in some areas of law more so than others, definitely there's statistics on that, because the Solicitors Regulation Authority and the Law Society, they do surveys every year where they look at the makeup of the profession. And it has been, and also Black Solicitors Network, for 10 years, we did a diversity league table where we looked into the demographics of the city firms. And so the evidence is clear that the most recent set of statistics, there is an overrepresentation of Black and ethnic minority lawyers who do crime and who now do immigration. As I said, years ago, very few lawyers did immigration at all, but now there is a large number do immigration and crime. So whereas the numbers who are in commercial practices are lower, the other area of law that you'll find a lot of Black and ethnic minority lawyers is also family law as well. And I think it's the areas of law that touches our own experiences and the people that we know. A lot of the work that we do, that we get, is from personal recommendation. I think you'll probably find that we get more personal recommendations so far as the work is concerned than any other demographic, and that is so we get the problems that our community are experiencing.
Yeah, I think I agree with that. Sorry, Cordella, I think my Zoom had stopped for a while, there we go. But yeah, I think I heard your answer to that question and I've read it, and yeah, I agree. I don't really find colleagues so much. Occasionally there are Commonwealth pupil barristers or trainee barristers that come along that might have issues, but they're not anything like the ones we have on a daily basis in practice. Generally speaking, it's I have a friend who has this problem. And yes, things have changed a lot. since I was called to the bar, but there's still a long way to go. And the next question is, how do you feel about the changes to immigration policy that Priti Patel intends to implement? I'm absolutely horrified. I'm pretty much horrified by most of the, if not all, of the policy changes that are announced by Priti Patel. They're extremely regressive, racist actually as well. And they don't give effect to this country's international obligations to protect individuals, and also the domestic obligation in terms of fairness and equality. So I'm quite outraged. So yeah, I don't know if you want me to go to the next question. I just did the one before. Yeah,
no, I'll just sort of, in terms of the immigration policy, as a judge, I cannot, I have to be impartial. But what I have to say is I did look at the draft bill, and I think a lot of it is actually impractical in any event. And so a lot of it is it's headlines. I would expect amendments as well. But there are some things, some provisions in it that are really impractical. And I do think that it's sort of more baiting than reality. And it was interesting today that the Crown Prosecution Service have said that it will not be prosecuting people. And so I think it's one of those, though, where it's one that you do have to watch, and that MPs have. One of the things, so far as immigration is concerned, even with Windrush, is that a lot of the laws that we now have and that have created problems, it's all governments are responsible for. It's not just one particular government at fault. And therefore, so MPs have been sleeping at times when these provisions have been coming in. So in terms of the Windrush generation losing nationality, those sort of things, MPs allowed to go through. And so it is important that MPs are lobbied on these sort of provisions. I wanted you, Grace, I was just asking if you sort of just quickly talked about sort of your day-to-day work, and then we'll go back to the questions.
Yeah, all right. So day-to-day work, everything that we say now has to be pre and post-COVID. Pre-COVID, I was in court quite a lot, not every day of the week, but around about 3 to 4 times a week. And that would quite often be the first tier tribunal and also the upper tribunal. I would also have see clients, so you don't just see them when you go to court, you're going to see them beforehand and have what we call a conference, which is a meeting with your barrister, and have a chat about the case and about how the evidence is going to be dealt with. I'd also have meetings with the solicitor, quite often with the lay clients, but not always. So that would be sort of a typical sort of look at about of a work week, but there'd also be a fair amount of drafting, and by that I mean for immigration work, there's a lot of written work, and if you contrast that with crime and to a lesser extent family work, there is a lot more written work, and Cordella's already touched on this. We call it black letter law, meaning that we are very much following the legislation, statutes, legislative provisions, etc. But post-COVID, most of that has changed. So there are hearings going on, but most of them are like this, not on Zoom, but some other remote platform. But most people are doing less hearings generally, so that the disputes are dealt with on paper, where possible. Where a hearing is necessary, we still have them, and we still have them in person if that's necessary as well. But I would say a large part of my work is what I call public law work. So that's work in the administrative courts, relating primarily to immigration and sometimes asylum matters in judicial review, but also community care where the subject or the individual is a migrant, and the local authority and or the Home Office have declined to offer them support and or accommodation, and quite often these people would be destitute and are destitute people. So I do a lot of that kind of work, and I would say that's 80%. Again, that's very much written work, so very much tied to my desk. I also do just a couple of other areas of law as well, so including community care. I do little bits of environmental law work, and just to add, which I should have added earlier, I also sit as a judge also, just like Cordella, but in the county courts, and I do that well, a minimum of 15 days a year, but sometimes it's more than that in a year, and it's fee paid in the same way that Cordella is, meaning it's part-time. So I fit that in as well to my sort of daily, or not daily, my weekly and monthly schedules. That's a sort of a snapshot really of the things I do.
Yeah. Thanks, Grace. I'm going to go back to Annie's question about politics and the media and immigration and the impact on our work. And as you said, we're both in similar situations, that we're fee-paid judges and also practitioners. And it's actually quite a difficult line to tread. If we're full-time judges, we probably couldn't have this conference at all, because our freedom to speak is much more fettered than it is as a fee-paid judge. But we have an obligation not to bring the judiciary into disrepute, and also not to show bias or what we say to indicate bias. However, it's also a bit difficult being a practitioner for one side, and then you go into court and you're supposed to be, and you then treat everybody the same, and so there obviously a little bit of your and that's the other reason for a diverse judiciary, because everybody brings something of themselves to their job, and it's no different for judges as well. And so if you have an understanding of both sides, having an understanding of both sides obviously helps in terms of impartiality. But in particular for immigration, that fettering it sort of comes from one of the parties. So that's what makes it so difficult, because the Home Office is the other party in all of the work that we're doing. It's not like in the civil court where you've got two individuals, two opposing parties. We've got an arm of the state who is the representative in. So it means that politics is brought into our jurisdiction, whether we want it or not, but we can't really comment on it in terms of my judicial work. I have to apply the law. As a practitioner, then I would be challenging the Home Office decisions as a practitioner, but as an immigration judge, I'm having to look at whether the decision of the Home Office is correct in law. That's the limitation of that. As I mentioned when I first started, that law wasn't very much, and that law was not particularly complex. That law now is amazingly complex, and for us as judges, it is very, very difficult for us to maneuver our way through it anyway. The Court of Appeal and the Supreme Court is having to try and manage it as well. There is so much immigration law that is under appeal. So it's a very different, and a lot of it is politics led as well. So and I think that creates some of the tension that you see coming from the Home Office, where there's complaints about activist lawyers and activist judges, because I think the government doesn't necessarily understand separation of powers in the way that a lawyer does.
Yeah, I think I agree with that, and I think yeah, it's completely tied, as the question indicates, together, and it's almost impossible to separate, because the rhetoric that comes from the government and also the tabloids and some general sort of media sources just tie all of that together. And I think one of the challenges for me is really to try to get my judge to see the justice in the case, to go beyond that rhetoric, which is really sort of right on the surface of everyday life. We see that asylum seekers, you know, they're taking council houses or whatever's being put in the press, which is obviously all wrong. And neglecting really to demonstrate how valuable migrants are to the UK, and really sort of just focusing on one or two sort of very negative, you know, sort of types of cases. When we look at the population generally, the British population will see the same pattern happening, that there are one or two at least negative people within the communities. So we really ought to sort of spotlight the migrants in that category. So that's really, yeah, it's not possible to separate it, it's all bound up. Any more questions, Cordella?
Yes, I was going to go on to, there's been a couple of questions about legal aid and funding, about constrictions on legal aid. I mean, so far as the solicitors are concerned, legal aid, again, has been restricted in most areas of law since 2000. That's when the legal aid transaction scheme came into being. And again, it's political in that governments don't actually see the benefit of legal aid, and they think it is. I do recall Lord Mackay, the other Lord Mackay, the Conservative Lord Mackay, when he was trying to introduce the changes in the mid-90s, saying that that legal aid was something you do at the beginning of your career before you move on and do something else. So that is how it is viewed. And the problem of it then is they don't understand why senior experienced lawyers would want to do legal aid, and why people who can't afford lawyers should have senior experienced people helping them with their cases. So it has been difficult. I mean, so far as my practice is concerned, I had set my practice did legal aid and private, because, as I said, it is not all asylum work, and so a lot of the legal aid is not available for non-asylum work, and so people do have to pay privately, and there are some people who can afford to pay, and so it is structuring the work that is done so that you do some of both if you can, and certainly as a solicitor you certainly can do that. Grace, I'll let you come in and say how it works for the bar, but certainly as a solicitor, you can structure your practice and structure your work so that you have, in my practice, my family law work and really subsidized the legal aid, that we did legal aid, but the legal aid didn't pay well enough to pay the bills. But the private work subsidized it, and that's why we could afford to then have two solicitors doing immigration still.
Yeah, it's very similar. Immigration work, and in particular asylum, has also always been subsidised in my practice. As you say, it was 2010 when legal aid was first made available, and before then, in the 90s, we would do a lot of pro bono work. Occasionally family members, because a different regime applied then, but family members who were settled in the UK could pay for a relative that came to the UK as an asylum seeker or refugee. But yes, so now I tend to do a lot less of the first year work, and first year work anyway, which is really poorly paid by the legal aid agency in terms of asylum. But for students and workers who are migrants, they tend to have access to funds, because one would need to, if you're going to qualify in that category. So they tend to be privately paying, and that private work can subsidise the other work that you might do in immigration and, in asylum, humanitarian protection work. The big subsidy for me comes from the judicial review work. So it's not all plain sailing, however, but essentially the bottom line is that if you get permission to apply for judicial review, quite often the Home Office will concede the case, and if they do that, then they will agree to pay you at a commercial rate, which is almost probably like 4 or 5 times the legal aid rate. It's an enormous difference. If you're doing a lot of judicial review and you're getting success doing that, and that's a big and, because you need to be successful, you will find that you will have a very, very reasonable income. And if you have the time, and hopefully you will be able to do a lot of pro bono work in asylum cases, and/or do 1 or 2 if you're at my stage of call, legal aid work as well for asylum. But you do have to find a way to balance the work to make it compensate for other areas that are much less well paid.
Thank you. I'm going to go to Susanna, who there are a number of matters there asking about a noticeable change in terms of winning immigration and asylum cases, and whether Brexit has meant Europeans now needing services more. I think the answer to in terms of winning, I think it's particularly so far as my day-to-day work as an immigration practitioner. I didn't sort of talk about what we as solicitors do. So with the solicitors, Grace is primarily dealing with appeals, I should imagine, whereas for the solicitor, we're dealing with the initial applications as well as preparing appeals. And so we are having to navigate the immigration rules in our office, at our desk with the client, trying to work out where they might fit within the rules or within the system, and submitting the application on their behalf. And so having a proper understanding, not only of the rules, but the policies behind them and the guidance behind them, affects your chances of succeeding in the initial application. And what I find as a judge is often the problem, there is often that at that early stage, there hasn't been that understanding, and it's been easier for the Home Office to say no as a result, because I think the Home Office is looking to say no. We know that, and it's having to try to, I suppose, pre-guess what the objections are going to be and make sure that you've covered all your bases when you put your application in the first place. So it's difficult to say that there's any noticeable changes in terms of winning, because I still think that if you really put in a good application in the first place, then your chances of being successful are so much better. But one of the distinctions I have noticed, having practiced for so many years, is because of those changes in the rules, and because as cases succeed, the Home Office switch the rules. And that is the greater problem, that because of all the switching in the rules, it makes it less clear what is being looked at, and how to put in a good application. The other complication we have is the Human Rights Act. When I started, it was just the rules. The Human Rights Act was not passed, although it was in principle accepted in domestic law, and it was not something. There was no right to a human rights challenge until the 1999 Act. 1990 Act came in, and so that gave the Home Office more discretion, and get more discretion to actually refuse, and that has actually made things more difficult. But I think at an appellate level, which is where immigration judges are, we hear appeals. So at the appellate level, whilst the Home Office has attempted to limit the discretion of the judges, the Human Rights Act has introduced a lot of discretion. But as I said, which then ends up being appealed further on, and that is what then complicates the legislation, because if one set of arguments starts to be successful, you'll find it's then appealed, and then you're back to square one with something else, and that's what makes it difficult and challenging, and difficult for you to just say it, in terms of winning cases as a whole, because it just doesn't work like that. It's a really Byzantine system that it's very, very difficult to explain.
Yeah, it is. I think, you know, it might be better to talk in terms of success, because you might have a success, or I might have a success in court, but it doesn't necessarily mean that the case is won. It means that that stage, if you like, has been successful. And as we know, it's not quite a battle in the war, but it might be the battle in the war, as it were, to the person getting their leave to remain in the end. I think I've always found that on appeal, there is more chance of being successful, because the Home Office tend to have a much higher rate of refusal. So it's not very good for claimants, but yes, if you get refused, there's a good chance, depending on your case, that you would be more successful at an appeal stage. And the appeal stage that Cordella is dealing with in the first tier tribunal, but also the upper tribunal and the Court of Appeal, which is part of the appellate process. Brexit, I think, the closing date for the settlement scheme has just passed, and all the indications are that there are a lot of people who were refused under the settlement scheme, and dependents, and it's very likely that there will be a lot more immigration work sort of coming through, because of people who've not been accepted, and all their dependents. Whether immigrants and asylum seekers have been targeted in a more pronounced way, I think so, in terms of law and policy. So we saw, for example, that asylum seekers were being kept in army barracks, which was recently held by the court to be unlawful. So that's not being targeted by an individual, but there is sort of policy or government opinion that this is the way that it's acceptable to treat asylum seekers in this way. Most of the NGOs and non-governmental organisations and human rights organisations condemn that sort of treatment of asylum seekers and migrants. Yeah, it's not really getting better in terms of how migrants generally are treated, certainly by the authorities, and that's just a big sort of categorisation of the authorities. I appreciate it's not everybody in government that has that view, but that view exists.
Yeah. There's a question about first safe country, saying that they can't find anywhere where that is stayed. I mean, that is the case, yes, that you're expected to seek asylum in the first safe country. I'm not sure if it's in the convention or in the protocols, but that is the case. However, it's just an expectation. It is not a requirement, and if you do look in the statistics in any event, you will find that the majority of people who are refugees seeking asylum, they do actually they are in refugee camps in very close to their own country, often next door. There are places, countries like Tanzania have the highest numbers of refugees. It is not countries in Europe. But so yes, that is the case. And someone asked about the relationship between immigration law and human trafficking. I'm not exactly sure what is meant by that, but we deal with. I think one of the problems is the conflation that we're having with the political discourse at the moment, where they're talking about criminal gangs and what have you, as opposed to what is really human trafficking and modern slavery. Because there is a connection between immigration and modern immigration law and modern slavery. But did you want to come in, Grace, then, before I go back to that?
No, that's fine, Cordella. You go ahead.
Yes, and so that as I said, we have a situation in terms of the bill that came out yesterday or today, that it is conflating trafficking and immigration law, although within the bill there is a section on modern slavery, which is more codifying how modern slavery claims should be treated, but they don't necessarily translate into the work that we do in that sort of straight way. But you might have someone who has been trafficked into the UK for the purposes of prostitution or to work, and they have a right to seek protection, but that is not usually their claim on arrival. That aspect of it usually arises during the course of an application, and there is a referral mechanism that within the Home Office to look at cases of people who may have been trafficked. So it's not having to prove that you were trafficked, but it's who may have been trafficked, and that is different to criminal gangs who are being paid to move people across borders. Great.
Yeah. And I could add to that in terms of the relationship, so someone who's been trafficked to the UK will likely also have an immigration case, which is separate. Immigration case could be to do with protection, asylum, humanitarian protection. But if they have been trafficked, and they will be referred to through the national referral mechanism to the single competent authority, which is a part of the Home Office, the outcome could be different. So that's where the differences are, because if the immigration case becomes successful, the person could get refugee leave to remain, which is 5 years, or they could get limited leave to remain. Whereas if they have been found to be a trafficking victim through the single competent authority, they would be firstly entitled to a period of just calm. I forget the name that they call it. Basically nothing really happens during that period of several months, and if they are successful, ultimately they would be granted discretionary leave, which can be extended. So the process, it's about process and how they've been dealt with by the Home Office, two different limbs of the Home Office.
Right, I think we've gone over time, so I'm going to, but just one quick one that it is a basic question. It's a sort of quick answer, asking what's the most common reason for refusal of an immigration case, and it's simply
credibility.
The Home Office doesn't believe it. Credibility. The Home Office just doesn't believe it.
Home Office doesn't believe
your story. So
and also says you're a liar.
Yeah, that's it. That it's a pack of lies. That's the common reason. Or in terms of asylum, in terms of immigration, you don't meet the rules. That has to be the reason that you don't meet the rules, and there is no human right, and there is no breach of your human rights either, because in asylum and immigration law there is a specific human rights the provisions within the Act, the Immigration and Asylum Tribunal has particular jurisdiction to deal with human rights, and so most cases are also there's a human rights decision as well as to whether or not, even if you don't meet the rules, it would breach your human rights, and the answer is usually, so far as the Home Office, so is that no, your human rights are not breached either, but the main thing is credibility, that you're not believed.
Cordella, before you kind of close, a couple of people have asked in the chat about getting experience, and people have asked me about this as well outside of this call. It's firstly, I would say it's not just you as an individual who is struggling to find experience. We are coming out of the pandemic, and during the pandemic, things pretty much came to a halt for many sets of chambers and many practice areas. So there is a backlog of people who are due to start. For example, when the more formal part of training to become barrister, for example, is pupillage, and there was a hiatus that just didn't happen for a good 6, 7, 8 months. Starting to pick that back up again now, but there's all sorts of impacts on people like yourselves on this call, or many of you on this call, who want to get experience, and I feel the frustration, and I thoroughly understand it, where you're being told you can't come into work because, or you can't work for us because you don't have the experience. Well, how are you going to get the experience? What I would say to you is you're doing the right thing coming on this call. You need to do more of this. You've probably done a lot of it already. You need to have that tenacity to keep pushing. We are coming out the pandemic, so hopefully things will get easier. It's not going to get easier tomorrow or next week, but just keep trying. This is something you want to do. Keep trying. So there's no magic here at all, no easy answers, and that's what I would say to those of you on the chat and who are thinking about this as well, is really just, you know, stick at it. Thank you.
And I would echo that as well. So far as firms are concerned, it's exactly the same scenario, that firms are having to reassess things. But one of the things I would say is also to be looking at the new routes, and the SQE is probably going to help in terms of, some of you I know will be looking for training contracts, and the 2-year training contract, we know, has BSN have been advocating for a long time that it is a real barrier for entry for Black would-be solicitors. And we do have the new SQE coming in October, and firms will start looking at apprenticeships, and quite a few firms are already starting looking at apprenticeships, looking at how they can do qualifying work experience, because you will be able to do up to 4 different sets of work experience in different areas. You don't have to do 2 years in a firm, so you could try to get, and it's equivalent experience as well. It's not the formally structured experience that you've had to have to date. So you could perhaps be getting some work in a legal department of a in-house, you know, in the legal department of the government legal services, or a company structure, anywhere where the work you're doing is of a legal nature that could be signed off as qualifying work experience as well. So I would say look at all the options. There are much more options available to you now, and so don't get despondent. It has always been a problem. It is nothing new. It's highly competitive. It is an elite profession, and that's why it is so competitive. But not to give up, because you will get there, but you do have to, it is not always straightforward, but try to get as much experience as you can, and it can be varied. It does not have to be in a solicitor's office. It does not have to be in barristers' chambers. Thank you. So I am going to wrap it up then, because I think we have gone over our time. So I want to thank you all for staying with us. There's still a large number of people there. As I said, if there's anything direct that you do want to ask us, send it through, and Eva, who's in the background, our operations manager, will forward it on to us. So thank you to Grace. I found it really interesting. And thank you all, and thank you, Eva, and have a lovely weekend and enjoy the football.